"He has killed my mate, and I'm going to stick him," the Briton growled. Eardley reasoned with his comrade, arguing that it was a cowardly act to kill a defenseless man. "Put yourself in his place, chum. One never knows. Cheer up, old pa. Don't do it. That's a good fellow," he could. Eardley managed to prevent the angry Lancashireman from killing the Turkish soldier. He found himself alone in the trench with the wounded Ottoman. The two men could not communicate in words, but the Turk made clear to Eardley that he was in terrible pain. "Poor fellow," Eardley muttered to himself as he bandaged the man's gaping head wound. He settled the injured soldier in a safe spot away from the line of fire, put a coat under his head as a pillow, and sat with him for a spell, exchanging signs and glances. When Eardley was called to take up sentry duty, he gave the wounded man a drink of water and a cigarette. I could see by his eyes that he appreciated the kindness, and as the old saying goes, one good turn deserves another. The Lancashire Fusiliers did not hold the Turkish trenches for long. A massive Ottoman counterattack drove the British troops back to their original lines. Eardley was left in one of the occupied Turkish trenches to cover the retreat of his comrades. He watched as his area was overrun by hundreds of Ottoman soldiers charging with bayonets fixed. The excitement was intense, beads of perspiration on my forehead, our foe galloping on in one great effort to sweep us off the face of the earth. He was surprised by a Turkish soldier who hurdled the parapet bayonet first. I felt a sharp, piercing sensation, a burning feeling at the back of my left shoulder. I knew I had got the bayonet. I distinctly felt the thrust and drawing out. Eardley fell face forward to the bottom of the trench among the dead and wounded, where, suffering from shock and loss of blood, he lost consciousness. Eardley was awakened hours later by the sensation of dirt being shoveled onto his back. As he struggled to stand up, dizzy and disoriented, Eardley found himself surrounded by hostile bayonets pointed towards his chest. He had no doubt they intended to kill him. But before his captors had the chance to strike, a wounded Turkish soldier with a bandage around his head leapt into the trench and protected Eardley with his own body. The Briton immediately recognized his deliverer. The injured Turk was himself quite weak. He had presumably just been rescued by his comrades in their recent counterattack, but he clung to Eardley for all he was worth and shouted for a sergeant. When the Ottoman sergeant finally arrived, the wounded Turk told his story. "Away they jabber," Eardley recalled, unable to understand a word of what his protector was saying, but recognizing from the expression on the sergeant's face that his chances of survival were rapidly improving. Finally, the sergeant turned and spoke to him in broken English. "English, get up. No one will harm you. You would have died only for this soldier. You gave him water, you gave him smoke, and you stopped wound from bleeding. You, very good Englishman," and patted my back all over. Before being led away, Eardley took leave of his Turkish friend. I shook hands with this Turk and would give all I possessed to see this man again. As our hands clasped, I could see he understood, for he lifted his eyes and called Allah, and then kissed me. I can feel this kiss even now on my cheek, as if it was branded there or was part of my blood. They never saw each other again. Jostled through a hostile crowd of Ottoman soldiers, Eardley was taken up to a communications trench for interrogation. Further on, a hostile soldier dealt Eardley a blow to the chin that knocked him out. He later came to among a handful of other wounded British prisoners. It was a rude reminder that for most Turkish soldiers, Eardley's English uniform marked him as the invading enemy, the Düşman. But Eardley's days in combat were over. He would spend the next 3 years alternating between confinement and heavy labor as an Ottoman prisoner of war. The trenches were taking their toll on the invaders. British and French soldiers were killed by enemy fire or taken prisoner by the Ottomans in steady stream, with a far greater number evacuated from Gallipoli to be treated for wounds, disease, or shell shock. Hospital facilities in Mudras, Malta, and Alexandria were filled, and a growing number of passenger ships were recommissioned as floating hospitals to cope with the sick and wounded. Many of those who remained in the trenches were too sick with dysentery to fight, but could not be spared from the thinned Allied lines. Meanwhile, Enver Pasha continued.
All right, is the sheriff's office there?
Yes, sir. Karnes
Hey, how you
County.
doing? I think Judge Ellison has the criminal docket this morning.
Yes, sir. Are you having Mr. Green?
Oh, I have no idea. Let me look. Yes, Heather and Jesse Green.
Yes, I think you have a civil with them, and then we're doing criminal on the other one.
Oh, okay, that's fine. All right, I just wanted to make sure that,
If you need him, we'll have him available here.
okay, I appreciate it.
Yes, sir.
Thank you, sir.
I know that.
There you
All right, ladies and gentlemen, I have about 9 o'clock. We'll go ahead and call the dockets, ask for announcements from the attorneys. Anyone who is present who doesn't have an attorney, or your attorney doesn't answer, make sure I know you're here. Apart from that, please keep your electronic devices muted. Start with Karnes County. Matter of the marriage of Heather and Jesse Green.
Jesse Green is incarcerated, Karns County.
Thank you. All right, is Heather Green here? I'll recall. Matter of the marriage of Elena and Christopher McCombs.
Ready, Your Honor.
I'm present, Your Honor, for the respondent.
Elena McCombs here.
All right, ma'am, your attorney's answered for you. Thank you. Okay, and what do we have to hear today?
Your Honor, this is a motion to appoint a business evaluator and conduct a business evaluation.
And how long to hear this?
About, I don't know, 20 minutes.
Excuse me. Both sides agree on the time?
Yes, Your Honor.
All right, excuse me for a moment. All right, I'll mark you conferring for the time being. I'm going to make Ms. Riley the court coordinator, office the host, and I will ask her to make me the co-host so she can set up breakout rooms. In the interest of Christian Aguirre, a child.
Judge, that case has been dropped.
In the interest of Ella Crutchfield, a child.
That case has also been dropped, Judge.
Well, here comes Heather Green. I'll recall that in a moment. John Burt versus One Way Services Limited Partnership.
Your Honor, I'm present on that. We have a default judgment. I would anticipate 10 to 15 minutes.
All right, I'll mark you number 1. I'm not sure what this is. Oh,
Judge, that's on Judge Ellison's docket.
Okay.
I believe it's a writ, possibly.
All right. Ought to be in Ray, but okay.
I'm not sure.
All right, Ms. Green.
Good morning.
Morning. Are you ready to proceed on your divorce?
Yes, sir.
Do you have your proposed divorce decree?
No, I took it to the courthouse. Signed and everything.
Okay, well, I'm going to ask you to, well, here's the district clerk. Let me ask them to unmute.
Okay.
Yes, Judge, we have it on the laptop and I can upload the chat.
I appreciate it. All right, I will recall this case.
Okay. Thank you.
Frio County docket. of the Zamzow children.
That case has been dropped, Judge.
Wilson County docket. Alicia and Matthew Stevens versus Whispering Oaks.
Judge, that case was previously disposed.
All right, good, because I wanted to see how it was going to take half an hour to hear an agreed motion to dismiss. Petition to change the name of a child, Sarah Swaggart.
I'm here. Valerie Stein.
All right, who's Valerie?
I'm the mother of Sarah Swaggart.
Okay. All right, and are you ready to proceed, ma'am?
Yes, sir.
Okay, I will mark you A. You'll be the first self-represented case that I call up.
Okay.
Okay. Anyone else told to be here today that your case was not called? All right, now we have someone who's logged on. It says John. I'm asking you to unmute.
Your Honor, that is my client. For
Oh, okay. All right, never mind. Okay, I'll let the attorneys who need to confer, and I'm going to attempt to log on. Oh, Mr. Grubbs, did you answer on something?
Judge, I'm here on the Stevens matter on the agreed motion to dismiss.
Oh, okay. I'm being
We
told
agreed.
previously disposed of.
Okay, thank you, Judge.
All right, so you're excused.
Thank you, Judge.
All right, so let me see if I can log on to the Karns County District Court without having my computer crash.
Maribel Cruz and Crystal Thompson, y'all want me to go ahead and put y'all in a breakout room? Yes?
Yes, and the window washer behind me too. He's gonna have to.
Okay. If y'all will accept breakout room 1, okay.
All right, Mr. Bryant, it's taking, I was able to pull up 2 returns of service, or it's indexed twice. No, I guess 2 returns of service. Are you suing someone individually also?
That's correct, Your Honor. The person who signed is general partner. What I have a preliminary matter to take up with that particular service this morning.
Yes, sir, go ahead.
I filed basically a motion to amend the service return affidavit for Jason Cogburn. Essentially what happened, Your Honor, was when I originally filed this case, I filed it against the 2 entities, the One-Way Services LP and the entity that was listed as its general partner on the Secretary of State's website, One-Way Services Management LLC.
Okay.
We served those defendants on October 29th, I believe. Let me make sure my date's correct. Yes. I'm sorry, we served those 2 defendants by private process server with a citation original petition on October 31st, 2020. 2 days before that, after reviewing the documents a bit more, I saw that Mr. Cogburn had in fact signed as general partner. So I amended and added him as a party and then requested a new citation and copy of the amended petition to serve Mr. Cogburn with personally. We did serve Mr. Cogburn with that on November 24th, 2020, and a affidavit was filed showing that he had been served. Last week, when I was preparing for this default judgment hearing, I noticed that in the return affidavit from Mr. Cogburn, it had
His original petition?
Correct. It had listed the original petition. I went back and looked at my records, and essentially what happened, Judge, is I have a request to the district clerk's office for the citation and first amended petition. That was mailed by the district clerk's office to me, in hard copy format. I took that, confirmed it was the first amended petition and citation for Mr. Cogburn. I put that in an envelope and sent it to my process server, who I use routinely. She's out of Austin, Corin Johnson, with Spare Processing Service. And then she delivered that to Mr. Roan Evans, who was the process server that served Mr. Cogburn. So anyway, Your Honor, I have confirmed with Ms. Spare that, what she did when she got my envelope in the mail is she scanned it. And so between last week and today, in addition to my recollection and my process, we've confirmed that the image she scanned and delivered to Mr. Evans was in fact the first amended petition. So my motion this morning requests that the return be amended to reflect that he was served with the first amended petition instead of the original petition.
I don't have any objection at all to that. In fact, that's what I always suggest attorneys do. But so do you have something sworn from her?
I have something sworn from me and something sworn from Mr. Evans.
Okay, Mr. Evans. Okay, yes. If you would just send that to me in chat.
Sure.
Because the only thing I see is the service members affidavit.
I will try to do that right now.
And without objection, I'll take judicial notice of the contents of the files.
Okay, it should be uploading now, Your Honor. And with that, whenever the court's ready, I'm ready to proceed. If
I'm ready. Go ahead.
All right. They may have pleased the court. Your Honor, I'm Noel Bryant. I represent the plaintiff, John Burt. We're here today to obtain a default judgment against all of the defendants in this case who have been duly served and have failed to appear and answer. I'd ask that the court take judicial notice that the defendants have been duly served, that they have failed to appear and answer, and that all the allegations in our pleadings are admitted as true.
I'll take judicial notice of that.
Your Honor, this morning, I filed a motion for default and it attached exhibits 1, 2, 3, 4, 5A, 5B, 5C, 6, 7, 8, and 9. And I'd ask that those be admitted into evidence.
They're admitted into evidence. Do you have a proposed order for me to approve that, or do you think you need one?
I've got a final judgment that I filed this morning as well.
Okay. All right.
And then if it please go, I'd like to call John Burt briefly.
Mr. Burt, would you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Go ahead, Mr. Bryant.
Thank you, Mr. Burt. I can share my screen, I would like to. Mr. Burt, can you see Exhibit 1 on my screen?
I can.
All right, Mr. Burt. In briefly, is this your contract with One Way Services LP?
Yes, sir.
And okay, that's your name there, right, Mr. Burt?
Yes, sir.
And the One Way Services LP who's named on here as buyer, that's the same One Way Services that's a defendant in this case, correct?
Yes, sir.
All right, Mr. Burt. And here you were selling 3.597 acres in Karn County for $400,000. Is that correct?
Yes, sir.
All right, Mr. Burt, did you receive your $400,000?
No, sir.
Okay. If I can refer you to paragraph 12. Mr. Burt, this in the special provisions here, it says buyer to purchase property within 1 year or less. Did One Way Services LP purchase this property within 1 year or less?
No, sir.
Okay, and then not concerned with the amount, but it says that One Way is going to lease this property for $10,000 a month. Did you receive all rent owed under this contract, Mr. Burt?
No, sir.
Okay. Here, it talks about if buyer fails to purchase with 1 year, that there is a liquidated damage provision. My question to you, Mr. Burt, it says 20%. Is that your understanding was that was 20% of the purchase price, correct?
Yes, sir.
Okay. Mr. Burt, who was responsible for paying the utilities during the lease term?
One Way Services.
All right. And Mr. Burt, I'm going to refer you to the signature block here for One Way Services. Is that Jason Cogburn's signature to the best of your knowledge?
To the best of my knowledge, yes, sir.
And GP, is it your understanding that GP stands for general partner?
That was my understanding.
All right. Okay, Mr. Burt, I'm going to show you what's been marked and admitted as Exhibit 2. Briefly stated, is this a record of all payments that you received from One Way Services to date?
Yes, sir.
Great. Very briefly, Mr. Burt, I'm going to show you what's been admitted as Exhibit 3. The date on Exhibit 3 of these photos, does that accurately reflect the date these photographs were taken?
I don't see a date on it, but
Right here.
Yes, sir. 7/10.
Who took these photographs, Mr. Burt?
I did.
All right. And is this the structure on the 3.597 acres that was the subject of your contract?
Yes, sir.
All right. And basically, this is your inspection, and you discovered the One Way had abandoned the premises, correct?
That's correct.
All right. So after discovering One Way abandoned the premises, Mr. Burt, I'm going to show you what's been marked as Exhibit 4. Did you enter into this contract after you discovered that One Way had abandoned the premises?
I entered into that after they were not going to close on the property and wouldn't return phone calls.
Okay. So the property that's described in this contract, Mr. Burt, Is it the same property that was described in your contract with One Way Services LP?
Yes, sir.
And the purchase price down here, so you were again having to sell the property for 190,000 instead of 400,000, correct?
Yes, sir.
Okay. Okay, Mr. Burt, I'm going to show you what's been marked as Exhibit 6, or entered as Exhibit 6. Do you recognize this to be the closing statement from your sale of the property to Colcam?
Yes, sir.
I'm going to show you what's been entered as Exhibit 7. Mr. Burt, can you tell me what this is?
Yes, sir. Apparently, El Oso Water, I personally own the meter. So when One Way, when we signed the contract, I had to guarantee payment until they closed on the property where they could transfer the meter into their name. And I guess it went to a collection agency. I got a call and there was $420 due on the account, or they were going to pull the meter.
To your knowledge, Mr. Burt, was this for water services received during the period that One Way Services occupied the property?
Yes, sir.
So this would have been what they owed under the lease, correct?
Correct.
All right. Mr. Burt, I'm going to show you what's been marked as exhibit, or what's been admitted as Exhibit 9. Does this document, well, let's just go down one by one. The $420.53, that's what's shown on Exhibit 7, the water bill, correct?
Correct.
And past due rent owed by One Way, 20,000, does that accurately reflect the amount of rent that One Way owed you under the contract but did not pay you?
Yes, sir.
All right, and then $80,000, does that accurately reflect the liquidated damages owed to you under the contract for One Way failing to close within 1 year?
Yes, sir.
All right, and then last, $130,000. Is that basically what you were supposed to be paid under the One Way Services contract for selling them the property, minus what you actually received from Colcam for having to sell the property?
Yes, sir.
Your Honor, I will pass the witness. And if there are no further questions, I would call myself.
All right. So you're asking for the damages from the loss of this sale and having to sell it at a different price and a 20% penalty?
That's correct, Your Honor. That's how we read the contract.
All right, I'm going to need to ask you to send me a copy of the contract.
Certainly. Let me, I think I can throw that in the chat, Your Honor, if I can figure out how to get back to it. There we go.
I suspect it's academic, but I don't know.
Certainly, Your Honor. It's paragraph 12, and Mr. Burt testified that the 20% referred to in paragraph 12 was 20% of the purchase price.
All right, so all right, so you're asking for what damages under paragraph 12. What other damages are you asking for?
We're asking for the unpaid rent that was owed under that was supposed to be leased for a year, and
Right.
Mr. Burt did not receive a year's worth of rent. We're asking for the unpaid water bill, and then we're asking for basically our cost of cover, the difference in the two contract prices.
Okay, what paragraph are you asking for the cover?
That's going to be the remedies provision of the contract where it says we can seek all relief available at law. And so essentially, Your Honor, we have a breach of this contract to pay Mr. Burt $400,000. And because of that breach, Mr. Burt had to put it back up on the market and mitigate his losses, and was only able to obtain $190,000 for the sales price. It is the specific paragraph here, and I'm looking for it here. So paragraph 15 default, and it's particularly paragraph 15A where it is has the X on it, enforce specific performance or seek other relief as may be provided by law. So the or in there and other relief as may be provided by law allows for recovery of basically the benefit of the bargain damages.
Paragraph 12. Following special provisions apply and will control in the event of a conflict. All right. Is paragraph 12 the only paragraph that provides for lease payments?
That's correct, Your Honor. At least that's in this. That's as far as I know. Yes, Your Honor.
That's Brian. Again, I suspect this is academic. It may be that this company or Mr. Cogburn, has a whole bunch of money in the bank you can go and levy against. But I'm going to have to see some case law or something from you before I let your client recover under both paragraphs. I read this in my superficial first reading as saying that they've taken it out of the normal. I mean, what's the point of having that 20% penalty? I mean, the idea is we're going to lease it for $10,000 a month for a year, and you can tag us for what, $80,000, whatever it is, as a penalty if we don't go ahead and buy it. So I'm not going to, without seeing some case law or something, allow him to recover under 12 and 15. If you need a breakout room to talk with him, or if you want to just reset this, that's fine too.
Would the court be inclined to allow us to make an election under either of those paragraphs?
Oh, sure.
Okay, sure. If we can go in a breakout room, that'd be great.
Okay, Miss Riley is the host.
If the court will just help me remember that I still have to testify on attorney's fees. I don't want to forget.
Go ahead, sir.
I'm going to invite you to breakout room 2. Mr. Burt, you'll get a little pop-up window inviting you to that room in just a second.
Okay, thank you.
And just click on it.
All right, Mr. Bryant, you're back.
Yes, yes, Your Honor, we are back. We would like to make an election. If we can look at Exhibit 9. Do you want me to throw that up real quick or?
If you want, go ahead.
Sure. Okay, Your Honor. So we would like to make an election, and again, just focusing on the benefit of the bargain. If we recover the 130, we're going to get our contract price, and then the $420.53. Again, that was part of the bargain. That was an out-of-pocket loss, and that was something that the tenant should pay for. And then we'll per the court urging, we'll certainly pass on the 20 and the 80 if the court would be inclined to grant us the 130 and the 420.
Yes, sir, I will do that. You solemnly swear or affirm that testimony you may give about attorney's fees will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, and I'll take judicial notice that you're aware of the value of attorney's fees in this judicial district. Go ahead, sir.
Thank you, Your Honor. In light of that, then I will move to Exhibit 8. And I guess just preliminary, Your Honor, obviously I'm licensed to practice law in the state of Texas and have been for 15 years. I do employ, in addition to myself, a paralegal who has 17 years of experience, and a law clerk, Morgan, who is a third-year law student. Our duties are segregated such that Mrs. Fox, paralegal, she primarily does document review, reviewing documents and preparing case chronologies. Mrs. Brubaker, billed at $105 an hour, does primarily legal research and motion drafting. In this particular case, I spent a total of 7.1 hours, which I have previously billed for, an additional 3 hours in preparation for today's default judgment hearing. Ms. Brubaker spent 6.8 hours on the case, and Ms. Fox spent 5.7 hours on the case. All of those hours are detailed in the attached billing statements sent to Mr. Burt. These billing statements reflect contemporaneous time entries, which all of us record and bill to our clients. The fees reflected on these billing statements were actually billed and were actually paid by Mr. Burt, and reflect all work done to date. The services reflected on these billing statements was reasonable and necessary at the time they're performed. In my opinion, Your Honor, is based on my education, training, and experience, let's see, there was a total bill to date of $2,978.50, with additional billings for today's work at $675. And my opinion is a reasonable and necessary and customary fee for prosecuting this case to default judgment is $3,500. In the event we are forced to respond to post-judgment motions, a reasonable and necessary fee for that would be $1,500. And in the event that this case is appealed to the Fourth Court of Appeals, A reasonable and necessary fee for representing my client on appeal would be $5,000. And last, if it is taken to the Supreme Court, a reasonable and necessary fee for work performed for my client would be $7,500. And I'd ask that the court award attorney's fees as stated on Exhibit 8.
All right, I'll award, find that the attorney's fees are reasonable and necessary, and I will award them, including the conditional post-judgment attorney's fees.
Thank you, Your Honor. With that, we will rest, and the proposed judgment I filed this morning, we can just scrap that, and I will file a new, well, I'll wait till the court rules.
Okay, no, I'll grant the relief requested after the election has been made. And again, I'll find that the parties were properly served. I'll order that the amended affidavit of service or return of service be filed by the district clerk's office and grant the relief prayed for after the election.
Thank you, Your Honor. And as far as the affidavit goes, I filed it as an attachment to my motion this morning. And what I have in the form proposed default judgment is actually a recitation that the service affidavit is so amended as reflected in the default judgment, if that's okay. At least that's, in reading the case law, it looked like that's the way I was.
Yes or no, that's what I always ask folks to do. It's just, okay. All right. I don't think I'm going to be on very long. If the court is still ongoing on Zoom, when you get that done, feel free to post it in chat. Otherwise, if you want to just e-file it, I'll sign it when it gets to my queue.
Thank you, Your Honor. Thank you very much.
All right, have a good day.
Thank you.
All right, give me just a second. All right, in the matter of the marriage of Green. All right.
Hello, Your Honor.
All right, now where did the SO go?
We're right here, sir.
Right there, oh, okay. All right, is Mr. Green, if we could get him on camera?
Okay, give me just a second. Let me grab him right quick.
Okay. Okay.
No, there was only chance even when he was as huge.
Your Honor,
Yes.
the jail is tied up for a second with a couple of things.
Okay,
Maybe a
that's
few
fine.
minutes before I can get Mr. Green up here.
That's fine. Just, I'll go ahead and start on another matter.
All right, thank you, sir.
All right, Mr. Green, if you'll hold on.
He's in custody, Carson.
All right, let me grab the file on the name change here in Wilson County.
Yeah.
All right. Ms. Stein,
Yes, sir.
okay, apparently your camera is not working.
No, it's not. I don't know why, but it's not.
All right.
I apologize.
Okay, and do you have your proposed divorce decree? No, not divorce decree, but your
I was
proposed,
like, wait.
your proposed, I'm sorry.
Yes, sir.
Okay, have you given that to the district clerk?
Yes.
All
And
right.
they have the original. I have the copy.
Okay.
Judge, we just have the petition.
Because the only thing that I found in the court's file is the petition. Now, the order is not the petition. You filed the petition to change the name. That looks like it was signed by you and your husband.
Oh, yes.
Okay, now the order is the order that you prepare for the judge to sign ordering the name and change. Do you have one of those?
Yes, we do.
Okay. Do you have a way and what sort of instrument are you on? Are you on a computer, on a phone?
A laptop?
Okay. Do you have a PDF copy of the order changing the name of the child?
PDF.
PDF is okay, that's the type of form that the document that is typically created whenever you scan something in with a scanner. You can also, there's lots of ways you can get a PDF. If you downloaded these forms from the internet, you probably receive them in a PDF format.
Yeah, it says the order is telling us what it says. Okay, Your Honor, we have a form that says order to change the name of the child. One says appearances, jurisdiction.
Yeah, that's it. But see, I don't have a copy of that and I can't proceed without a copy of that. So.
What?
Okay, so what do we need to do?
Okay, who's speaking?
Sorry, my mother-in-law is with me.
Okay, all right.
I get very nervous with this. I'm sorry.
Okay, all right. So where are you?
In Floresville, Texas.
All right. So why don't you bring your copy of the proposed order down to the court building so that the clerk can give it to me?
Okay, you're in Floresville?
Yes, Ms. Stein, did you come and file this directly with the clerk or in person, or did you file it?
Yes. Yeah, we took it to them, and then we asked if they needed that one, but they didn't.
Well, but that's fine. They don't need it to get it filed. You need to have a copy to the judge whenever it's heard. Okay, so if you will get that to the clerk's office, and then you can come into the courtroom at that time, and we'll finish it up here.
Okay.
All right.
And I can do that today.
Well, I'm holding court right now. You can do that right.
Okay.
Yes.
We'll go now.
Okay.
Okay.
All right.
Thank you.
Your Honor,
Yes.
Mr. Green is now present.
Okay. All right. Calling 19-8-00210, the marriage of Green. Are both sides ready?
Yes, sir.
All right. And is Jesse Lee Green here?
I'm present, Your Honor.
All right. And are you ready to proceed, sir? In your divorce?
Yes, sir.
All right. Let me ask both the parties. Do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir.
Okay. All right. And let me just ask Mr. Bryant, I see you're back.
Yes, sir, Your Honor.
Did you need to talk to me?
I was just going to drop that default judgment in the chat, Your Honor. I've read.
Oh, okay. Thank you. Go ahead.
Thank you.
All right. All right, Ms. Green, prior to the time you filed this lawsuit back in August of 2019, had you been a resident of Texas for 6 months and of Karnes County for 80 days?
Yes, sir.
You are married to Jesse Lee Green?
Yes, sir.
All right. Has the marriage between you and Mr. Green become undermined due to a discord or conflict of personalities?
Yes, sir.
Is there any likelihood? All right, and Mr. Green, I'll let you ask questions in a moment, and I will ask you some questions in a moment. I'll ask you to hold on for right now. Is there any likelihood, Ms. Green, that the two of you are going to reconcile and live together again as husband and wife?
No, sir.
Okay. Now, there were two children born to you and Mr. Green. That's Ryan and Macy.
Yes, sir.
I'm sorry, excuse me.
No, it's okay.
All right, I'm sorry, I'm back.
That's fine.
And you went to the court with the Attorney General back in August of 2018, and there was an order entered for child support, medical support, and possession of the children. Is that correct?
Yes, sir.
And you're asking to simply have that order incorporated into this divorce decree and not be changed?
Yes, sir.
Okay. And do you believe that's in the children's best interest?
Yes, I do.
Okay, now, I want to talk to both of you just for a minute, to make sure we're on the same page. The law in Texas says, presumes that everything a married person owns is community property. So when you're not married, everything you have is your own separate property. But the moment you say I do, the law just presumes that whatever you own is community property. In the divorce decree, that needs to either say it's community property and it's being split up, or say that it's not community property because, for instance, you owned it before the marriage or you inherited it, and therefore it's not being split up. If that doesn't happen, then the law presumes that the judge, forgot to divide part of your community property and that you still own it together, even though you're divorced. And decades later, the ex-spouse or the creditors of the ex-spouse can come back in and say, hey, wait a minute, Judge Wilson forgot to divide their property, part of their property. So if there is anything valuable enough that there might ever be a lawsuit over it, automobiles, real estate, cattle, tractors, anything like that, then we need to spell out in the divorce decree who gets it. It doesn't matter whose name is on it. It's just, if it's valuable enough, there might ever be a lawsuit over it. You need to go ahead and have it spelled out. who is going to receive it. So let me ask, is there anything that is not listed, because there's nothing listed?
No, sir, there's, we had no real estate, no assets, no property, no anything really of value that was worth fighting over.
Okay. All right. Now, there is a blank that was left blank in the proposed divorce decree I've been given that is for a date after which each of you is supposed to be responsible for your own bills. Typically, people will use the date they separated, but you could use any date up to the date of the divorce. So
Okay.
what date would be good to use?
Today's date would be fine. There's really nothing that we pay together. I pay all my own bills, and Jesse was paying all his own bills.
All right, and I actually need to back up for a moment, Ryan. The other thing I need to you is that the husband is presumed to be the father of any child born during the marriage and for, I think, 270 days after the marriage. Since the date of your marriage to Mr. Green, have there been any other children born to you?
No, just
Okay,
just the two that we had together.
All right. Are you expecting a child?
No,
Have you adopted any children?
no, sir.
And you're asking to have your name changed to Heather Marie Ramos.
Yes, sir, that's my maiden name.
Okay, all right. All right, Mr. Green, at this time, do you have any questions for your wife?
No, Your Honor.
Okay. And is there anything that your wife testified to that you disagree with?
No, sir.
Okay. So you're ready for me to grant the divorce, just saying that whatever the order was with your children that was done in the AG's order, that I'm going to adopt that, and that each of you just gets to keep your own property and pay your own debts?
Yes, I just.
Go ahead, Mr. Green.
I just want like us to have the same amount of custody over the kids, like. That's all.
All right, sir. Well, have any pleadings filed by you asking to change the previous order? So the previous order is from the 2018 when you were in the Attorney General's court. Your wife is just asking to have that incorporated or joined into this divorce decree because the divorce and the children are together. So you're asking to have that changed.
Yes, sir.
Okay. All right. You understand, sir, that you haven't come in and filed any pleadings, though, asking to have a change made.
Yes, sir. I understand that.
All right. And one last thing. There's also blanks in here about retirement that were not checked.
Okay.
Do either of you have an objection to me checking the box that says each of you is awarded any retirement that you earned during the marriage, other than Social Security? And I understand you may say you don't have any. What I've seen in the past is that lots of times people, they work for Walmart for 6 months, something like that, and they've got 2 shares of Walmart stock in a profit sharing plan or something like that. If I don't check off in the divorce decree who it's divided to, then you can never get clear title to that in the future unless you come back into court, file a motion to have the divorce decree clarified to say who gets that property. So do either of you have an objection to me doing that?
No, sir.
Mr.
No, sir.
Okay, all right then. I'll find I have jurisdiction to hear this matter. The case has been on file for more than 60 days. There is a return of service on file against Mr. Green on the divorce. He's also appeared in open court and announced ready. The petitioner was a resident of Karns County for 90 days and of Texas for 6 months prior to the time this lawsuit was filed. There were 2 children born during the marriage and no other children were born, adopted, or expected. And I find that the proposed order that was made in the child support case with the Attorney General's office is still in the children's best interest, and I will incorporate it. And I have gotten a copy of that from the district clerk's office and attached it to the proposed divorce decree. There were no other children born, adopted, or expected, and I will find that the proposed division of the marital property and debts is just, fair, and equitable. I will approve it. I will restore the petitioner's previous name of of Ramos.
Yeah.
Grant the divorce in open court. All right. I wish y'all good luck. I'm going to post this divorce decree to the district clerk's office right now. Let me make sure that that's going through. No, I posted them the wrong document. Pardon me. That's.
Sorry, excuse me.
All right, give me a moment. One of the many mysteries of Zoom is how
To upload documents.
no, it's not that. It's that I go to upload the document and let me just make sure. Yeah, it's in my Karn's folder. Go to upload stuff, it doesn't show it there.
Your Honor, if I could say something to Jesse, I would appreciate it.
All right, do you want to be placed in a breakout room?
No. It's just
All
real
right.
quick. I just wanted, do you understand that the child support is the visitation, or I mean, not visitation, but the custody is gonna stay the same? Like, you get them every other weekend and I think a Thursday, and I get them like we alternate holidays, right? Like you understand that that's how it's gonna continue to be?
Yes,
And
ma'am.
that's fine?
Yes, that's fine.
Okay, I'm just checking. I just wanted to be clear.
Yeah, that's fine.
Okay.
And now here it is. I just keep opening it up and sooner or later the divorce, it'll show it.
Okay.
I have a lot of frustrations with this program. Okay, I uploaded the signed final decree of divorce to the district clerk's office, and there's one other document that you need, ma'am. That's
Okay.
BVS, or Bureau of Vital Statistics sheet. And what that is that it is a document that is fill in the blank form that gets transmitted to the Austin to report this divorce to the state. Have you prepared one of those?
No, sir, I wasn't aware that I needed to do so.
All right. If you're able to, are you on a phone or on a computer?
I'm on my laptop.
Okay. You can download one from the internet, or the district clerk's office may be able to post one to you. We'll typically require that you file that with them before you give you a copy of your divorce decree, but I have filed the divorce decree or sent it to the district clerk so they can get it filed.
Okay, so how soon do I need to turn that paper in?
The sooner the better.
Okay, and then is that to the district clerk's office?
Yes.
Or
Yes, and let me ask the district clerk, do you have a PDF copy of that?
Yes, yes, Judge, we already have a copy. She's already filled it out.
Oh,
I did.
you filled it out? You're way
I
ahead of
guess
yourself and didn't know.
I know, I didn't even realize.
Okay. All right. You are excused then, and good luck. And Ms. Ramos, Mr. Green. Let me this.
I didn't even realize I filled out that paper. No.
All right, and let's let SO know we're finished. Mr. Green's excused.
Thank you, sir.
Okay, and the second copy that I just posted to the clerk's office of the final default judgment is the correct one. Mr. Bryant, I'll send you a unfiled stamp copy.
Thank you very much, Your Honor.
You're welcome, sir.
May I be excused?
Yes, you're excused.
Thank you. Y'all have a great day.
All right, matter of the marriage of McCombs.
Yes, Your Honor.
All right, where do we stand?
We cannot come to an agreement. We need a hearing, Your Honor.
Okay, who all is going to be testifying in that?
Honestly, I don't think it's an actual testimony kind of hearing. We just are having argument about whether we need to have an individual appointed in a business valuation. But Ms. Thompson, what do you believe?
Well, I announced that I was present for my client, the respondent, Mr. Chris McCombs. And Your Honor, he is he has custody of his 4-year-old nephew who came down with the norovirus last night and this morning. So if the court, after hearing argument, is inclined to get testimony, he's not available this morning. So that's my only issue. I'm here to present argument. And if the court needs something further from the parties, he would not be available this morning.
All right, I understand that. And I'm sorry, who's the movement?
I am Miss Alana McCombs' attorney. I am Maribel Cruz representing Alana McCombs.
All right, go ahead, ma'am.
So, Your Honor, this is a divorce case, obviously, and husband and wife own a business entity entitled Prestigious Palette LLC, doing business as Shorty's Restaurant. I think you probably know of it. It's there off of 181.
Yes.
Parent parties own this business entity, Prestigious Palette LLC, as equal owners. And at this time, pursuant to an agreement between husband and wife, husband is operating that business solely on his own, actually operating the day-to-day operations and then operating the back office of the financial data. Prior to the divorce being filed, Alana McCombs did most of the back office work and the husband did a lot of the front office work. And so at this time, the wife has nothing to do with the business, and she is seeing that the financials in the business are taking a different turn than what they were doing while they were married. And we cannot seem to agree on the value of this particular business entity. We obviously the wife believes that the value of the business entity is higher than what the husband believes the value of the business entity is. And so without a proper valuation of the community assets, the court can't properly exercise its discretion in making a just and right division of the community estate. Because of that, we are asking that the court order a business valuation. We propose doing something with a CPA for a forensic valuation. I would suggest someone like Rebecca Tiller, who is a CPA here in San Antonio and has provided forensic testimony in the past and valued businesses in the past in other cases that I've been involved in. And so we're requesting that the court order a business valuation with a forensic valuation component to it.
And would that be just someone looking at the finances and saying, here's what the business has been making in the past?
So essentially, it would be a value of the business of what it is current value is. I believe that she has the opportunity even to provide somewhat of a fair market value on the business. And then on the forensic accounting side, after looking at the financials, my client is finding that the husband is utilizing the business account for personal business and personal purposes, and has been paying individuals in cash rather than through the employment ADP. And so thus, now we're a lot worried about potential liability when these two individuals are 50% owners.
Well, but that seems like a different issue than the valuation.
In a way, it certainly is, which is why the request for a forensic evaluation is to be able to determine what the value was prior to the divorce being filed, and then the value since the temporary orders have been entered and his taking over the business.
Okay, Ms. Thompson?
Thank you, Your Honor. The problem here, if you look at the temporary orders that the parties entered.
No, I don't have a copy of those. So.
Would the court like me to share my copy?
Sure.
Okay. The parties had an agreement about what we were going to do with this. And Ms. McCombs obviously wanted to keep tabs on him, but one of the problems my client was having is that two people cannot run this business at the same time. I understand that Ms. McCombs has her concerns, and if my client were here, he'd tell you about his concerns when she was running the business and her personal dips into the accounts. None of those are necessary for forensic issues. This is, as the court knows and has already recognized, this is a restaurant. If Mr. McCombs decides to quit working in a restaurant today, there's nothing illegal about that. There's nothing Ms. McCombs can do about that. She cannot force him to work and operate this LLC. She has decided she doesn't want to be down here working and operating this LLC. She's moved to Carrollton with the party's child and wants to keep tabs and thumbs on how this LLC is going now, when in essence, it's just a restaurant. It is a small restaurant owned and operated, well, I shouldn't say owned, operated by an individual. And so, yeah, sure, we're going to disagree about the value because Mr. McCombs doesn't have to wake up and go to work tomorrow. And Ms. McCombs doesn't have the right to make him. And so all of the things the court has already correctly pointed out, these aren't forensic issues. These may be irritating issues to Ms. McCombs, who's not part of the business anymore. And she can make those claims and she can present that evidence at trial. But the problem is, as this court probably knows and has dealt with, small town and smaller restaurants don't make a lot of money paycheck to paycheck. And that's one of the things, ironically, Ms. McCombs is complaining about. She gets $2,000 a month salary to do nothing for the business. If Ms. McCombs wants to use her money to pay for somebody to look at the books, I assume that that's a perfectly good use of her money, and I can cross-examine that person at trial. But we don't have a lot of money in this case. They know that. The 2019 tax returns are coming to me. I don't have them currently, but there's not a lot of money in this business to pay for it. And our position is Ms. McCombs can do whatever she wants with her income. The parties additionally own a house in Carrollton where Ms. McCombs is, but her daughter is living in it. So we're receiving no income from that house. We would like the house to be sold. If this is what they want to do, if this is what Ms. McCombs wants to do with the party's community estate, I would assume that is her right, but we don't have any individual funds to pay for this. We don't believe it's necessary. There's not enough money in this case to warrant a forensic. But like I said, again, if Ms. McCombs has some money that she has access to, and this is what she wants to do with her side of the litigation, that would be her right, and we will cross-examine that person when and if the time comes. But this has been on file since early 2020, Your Honor, and we need to get it to the end of the line.
May I respond, Your Honor?
Yes, ma'am.
So Ms. McCombs, and I think it should be important to understand that the request that I made and the argument that I made to the court had nothing to do with personal digs and personal fights about who gets what money and who's doing what. It was strictly an argument in regards to the business entity and operations of the business entity. So in this situation, though, because Ms. Thompson brought up the personal portions of this case, I must let the court know that Ms. McCombs does not have a job, has never had a job. Her job has always been to run this business. This is a 20-year marriage. They have a special needs child. She is solely responsible for the special needs child at the moment and is living in Dallas in the marital residence with her other children because she has nowhere else to live. At the time that these two parties filed for the divorce, they were living in an RV in the parking lot of Shorty's place. She had nowhere else to go but to go back to Carrollton once the divorce was filed. She is the respondent in the case. And if the court saw and noticed in the Rule 11 agreement for temporary orders under two sections, the first one was—
You have the way it's docketed, it says in the matter of the marriage of Elena and Christopher McCombs.
You know what? Yes, I stand corrected. You are correct. I apologize. Because I had been involved in this case prior to, there was the concern that he was going to end up filing the petition for divorce because they had already been under those discussions prior to. And so I stand corrected. I did end up getting it on file prior to the husband doing it. When she came to see me, she actually thought that he had already filed. So I stand corrected. Please excuse my mistake.
Go ahead, ma'am.
All right. So moving forward in the Rule 11 agreement under Section 2, the husband was awarded the temporary exclusive use and possession of the business, which included the management of the day-to-day operations, the purchases, the payments of all the expenses and debts. And the only form of income that Mrs. McCombs had at the time that this agreement was made was through the business. And the argument was that the business could not be operated by two individuals at the same time. One of them had to do it. And since honestly, his mother is the owner of the building itself where Shorty's place operates, then it only made sense for the husband to continue to maintain and operate the business. So right now, Ms. McCombs has been living far away from the business, not knowing how the operation was going. And while she can't necessarily, and I agree, make the husband operate the business in a productive manner as it was prior to her leaving the business, what we can figure out is what is the value of the business. And the only way to do that is to do a business valuation. And the only income that these two people have is the business itself that they both own 50% of. And so because of that, the business, the expense of paying for the valuation should come from the business itself, since that is what we're trying to value in the first place. And again, the wife has no job. And the only form of income she has is the $900 of child support that the husband has been paying, and the $2,000 that's ordered under that's agreed under the agreement for this, salary, but that's technically spousal support. And that's kind of how we were able to couch it. Other than that, she gets nothing else. She has no other form of income. And there's no other way to be able to pay for this valuation other than through the business itself.
All right, so the real estate is not part of it?
No, it's not, Your Honor. And that's an important part of this. The LLC doesn't own anything. It's doing business and operating as a restaurant. So it doesn't own supplies. It doesn't own any, there's nothing there. And to say
who owns everything?
Well, it's all in the LLC. Everything's in the LLC, but the land where the restaurant is operating is owned by my client's mother. So the problem there is the LLC itself doesn't own anything of real value unless Chris McCombs is waking up and operating a restaurant every day. That's it. And to say that the only way to value any piece of property in a marital property with a business valuation is simply not true. We can put on evidence. The parties who own property can put on evidence, and they can be cross-examined, and they are allowed to testify pursuant to all of the case law and marital property in Texas. They are allowed to testify as to their own opinion of what their property is. And right now, their property is an LLC that owns nothing except the work ethic of Chris McCombs.
And respectfully, I do need to tell the court that the business actually, unbeknownst to Alana McCombs until the divorce process began, has a mortgage on the property itself, and the mortgage is being paid to the mother. Ms. McCombs didn't know anything about that until after the divorce had been filed. And so, at this point, perhaps the valuation is going to come back and say that it is a negative value, in which case we need to know that too. I don't know. And these two individuals are going to end up, one's likely going to overvalue it, one's likely going to undervalue. And how is the court going to be able to determine and discern what the value of this property is without having a third party look into the value of the business and provide the court with additional information?
Okay, and what do you mean by there's a mortgage on the property? I understand what a mortgage is, but what does that matter if they're just a tenant? Is there a contract to buy it, or?
It's a contract for purchase. It's not a rental or a leasing. It's a contract for purchase.
And does your client have a copy of that?
We received it even outside of discovery, we received it after discovery responses were provided, yes.
But the income tax returns haven't been done for 2019 and 2020?
No, they have been done, Your Honor. I just haven't received a copy yet. I don't know if Ms. McCombs has a copy or not, but she has them. So she would be familiar with the income.
But the issue with the income tax returns is that the way that you create the income tax returns versus the actual running of the business are two totally different calculations and methods for creating them. So income taxes might be able to show gross receipts. What it's not going to show is cash payments received by the parties who are sitting in the business entity itself and what they do with those cash payments.
I don't think I understand that, but the 2019 tax return shows the income available to the parties, which I'm sure Ms. McCombs will testify is very limited.
All right, and have the 2020 taxes been done?
I don't believe so, Your Honor.
And I don't know the answer to that question. I apologize.
Okay. All right, I'm going to deny the motion for right now. And I have to say that I don't see that a forensic accountant, yes, if there's been siphoning off of funds into somebody's pocket, obviously a forensic accountant would be appropriate to look into that and see if that has happened and how much and when. I don't know that how much an accountant would have to say about the value of the business other than what it has made in the past. And I don't know how much relevance that has to what a restaurant, if y'all ever been there, in a location with not very many people around it. This is a very rural location. It's an unusual restaurant in that when Cotton ran it for decades, it was, people would drive for miles and miles to see it, but it's got to be one of the restaurants that's most dependent on the state of the economy. Because if people, aren't feeling flush, they're not going to get in their car and drive 30 minutes through the countryside to go have a steak. and that's in my offhand opinion. So if, I'm not saying that I wouldn't absolutely reconsider it if there's a particularized need, but I don't see that just a forensic accountant is going to be able to give a whole lot of insight into what a restaurant's likely to be worth right now and the next however long, as far as a steakhouse in Falls City, Texas. That's dependent on so many things. And if the oil field comes back, it might be standing room only. And if it doesn't, there may be cobwebs. And so for right now, I will deny the motion. That's without prejudice. If we get more facts in the future, or have someone who would have more particularized ability to offer a educated opinion about what a restaurant in the unusual circumstance of Shorty's would be.
Well, and in that instance, Your Honor, the other individual that, and I was trying to figure out which direction to go. There is an individual named Stefan Lagmart with Alamo Brokers of Texas that provides testimony on the fair market value, like either sale value or purchase value of businesses. He has been used in cases like bankruptcy court when being able to provide the court with information on what the value of this particular business is based on somebody else coming in and purchasing the property and whatnot, or the business itself.
Okay, but could these experts, without the income tax return showing part of the year with COVID, could the experts give a valuation?
Well, the business,
it's changed so many things, especially the restaurant business.
well, but it's two things.
I mean, a 2019 evaluation of what Zoom is worth based on their 2019 income would be, I think, irrelevant to what it's worth today. That's an extreme example, but
valid. But when we do set the case for final trial, which Ms. Thompson and I have been talking about going to mediation and setting the case for trial, the court can only value the property based on the time that we are sitting in at the moment. So if they're
exactly, but that's why I would have to have an expert convince me that they could give a valid opinion based on the 2019 taxes and income statements, because so much has changed in the restaurant business since then, where it cratered and now it's coming back. And is it going to go back all the way?
Well, and the point that I was attempting to make was that Mr. Lagmark is an evaluator that values the fair market value, basically the purchase price of it, what someone else, a undisclosed individual willing to purchase into this business and operate this business. It's not dependent on tax returns or the financial data. It's more dependent on the business that is currently operating at the time and whether an individual would purchase this property. Fair market value is another method of valuing a business, one that you just had discussed about the value of a business in 2019 versus the value of a business in 2021. We set this case for final trial. We're going to have to provide proof of what this value, fair market value of this business is. And so perhaps somebody like Mr. Lagmark would be a better individual suited for being able to provide the court with what is the value of this business, rather than just looking at the fluctuation of the income and debt over time because of COVID.
Right. I've denied the motion for the time being. Obviously, if you get the 2019 and the 2020 numbers and you have a more particularized proposal, I'll certainly consider it.
Thank you, Your Honor.
Thank you. May we be dismissed?
Yes, ma'am.
Thank you.
I'll get that worked out.
Thanks.
Judge Wilson, on this name change, they're going to reset on requests. They couldn't get the other signature today.
Okay.
So
all right.
That takes care of Wilson. I'm going to sign off if that's okay.
That's fine. I think that takes care of everything. Let me go back and look. All right. Have a good day.
Bye, Victoria.
Did you ever stop at Shorty's, Lachey?
I have, a long time ago.
It's
Never heard of it.
been there in the last year or so. It had a great reputation of one of the few places you can get frog legs.
Oh, my dad loves frog legs.
Yeah. All right then. Do you want to go over the dockets?
Oh, we done?
I
Yes.
think I've got everything, Judge, but sure we can go over it.
All right.
Oh, the Christian Aguirre is done? In the matter of the Christian Aguirre?
What
For some reason.
was that?
Karn's.
That was dropped.
Oh, drop. I
Yes.
missed that one. I thought they
Yeah.
were conferring.
So green final judgment. McCombs reset on request. We had something else. Aguirre reset on request. Crutchfield reset on request. The Frio County case was dropped. Let me open the Karn's add-on. Burt versus One Way final judgment. Judge Ellison's hearing the writ for Avila on the Wilson County cases. Stevens versus Whispering Oaks was previously dismissed, and Swaggart is reset on request because they did not have their order completed. So I think that's it.
That's it, Judge. And
All right.
I don't know, have you been able to send me your dockets from yesterday, Judge?
No, let me look on, I sent you everything except Atascosa with all the tax stuff because they never have filed or they had not as of yesterday afternoon, filed their proposed orders. So I'll send you everything else if they have those today.
Yes,
I was
sir.
hoping to get those done. Yes, ma'am. In Karnes County? You're. Yes, ma'am.
Okay, no, I just wanted to see if I could be excused.
Yes, and did you get the
divorce and the
other one?
default judgment? Yes, sir.
Okay, all right.
No.
All right, we are finished. I'll see y'all soon.
Right, y'all have a visiting court reporter tomorrow.
Yes.
What do we have tomorrow?
That's that one that
Special
wasn't
setting.
heard
Monday.
from Monday, Tuesday, whatever that date was. It's JW Power and the Frio County appraisal.
Right.
And Pam
And-
Marcinick is going to be.
But yes, no, Karnes is excused, Lachey too. And what do we have on the 29th? What do we have?
29th, let's see.
That's a Friday, I think, and I have a special setting.
On the 29th, no, the 29th is a Thursday. We just have a regular, we have 10 cases set so far on that docket. Are you talking about the 30th, April 30th? The 20 is a Friday. I don't think you have anything.
Okay, I've got to go back and look. I've got
On
the pattern jury charge committee meeting one of those days. Let me go back.
Oh, on the 23rd, there was something, but that one got dropped, that Child Protective Services case, but that one's getting reset to another date. Let me look on the 30th, let's see.
On the 21st.
I don't have anything for you on that.
Okay, I'll go back and check the dates. I thought it was a Friday.
7th is a case set, a special setting under Frio County as well. I sent the invites out on that.
Okay.
But that's it, I think.
All right. Okay, well, I'm going to take off. Have a good
All
day.
right, Judge, I guess have a good weekend. No, I'll see you tomorrow.
Yeah, right, bye-bye.
Take care, bye.